The continuous residence and physical presence requirements can be a point of confusion for many permanent residents, green card holders, when applying for U.S. citizenship through naturalization. If you like this video and want more information about naturalization, please like and subscribe to our channel. We add and update information about citizenship through naturalization regularly. Our goal is to help you become U.S. citizens the right and easy way. Understandably, permanent residents may want to visit family and friends in their home countries by traveling for extended periods and returning to the United States. For these permanent residents, it is important to understand how long absences from the United States can affect eligibility for filing Form N-400, application for naturalization. Maintaining residency in preparation for citizenship application. The purpose of acquiring a green card is to establish U.S. residence and possibly work toward qualifying for U.S. citizenship. But if you leave the U.S. with the intention of making your home elsewhere, you will potentially give up your U.S. residency. One way that this will be discovered is if you spend long periods of time outside the United States, though, contrary to popular rumor, simply coming back to the U.S. every 6 months or a year is not enough. You can lose your U.S. residency in a day if you leave with the intention of moving to another country. Factors that will be considered include where you maintain your home, where you work, where your car is registered, where your family lives, and so on. What is true, however, is that if you stay away for 6 months or more, you will face a lot of questions upon your return, and if you stay away for a year or more, you will be presumed to have abandoned your U.S. residency. Most people can apply for naturalized U.S. citizenship 5 years after becoming a lawful permanent resident. That time period reduces to 3 years if you have been married to and living with a U.S. citizen the whole time. However, half of those 5 or 3 years must have been spent inside the United States before you can become eligible. When you apply for citizenship, you will be asked about all your trips outside the U.S., and those time periods will be taken into account in determining whether you are yet eligible to apply. You have been physically present, that is, lived in the United States, for at least half your required years of permanent residence. This is usually 2.5 out of the required 5 years. Note: when counting the total number of days you have been out of the country, include all trips you have taken outside the United States. This includes short trips and trips to Canada and Mexico. For example, if you go to Canada for a weekend, you must include that trip when you are counting how many days you have spent out of the country. Not required: 5 years as a permanent resident without leaving the United States for trips of 6 months or longer, if you were out of the country as part of your service. This time out of the country does not break your continuous residence. It is treated just like time spent in the United States. Generally, partial days spent in the United States count as whole days spent in the United States. There are small groups of applicants who may count time abroad as time in the United States for the physical presence requirement. An example of this exception is an applicant who is abroad in the employment of the U.S. government, or, for example, any time spent in the U.S. Armed Forces counts as time in the United States even if you were stationed overseas. Students may apply for naturalization either where they go to school or where their family lives, if they are still financially dependent on their parents. Physical presence in the United States. Physical presence means that you have actually been in the United States. Most applicants must be physically present in the United States for a certain number of months to be eligible for naturalization. Another important concept with regard to eligibility for citizenship is continuity of residence. What is the difference between physical presence and continuous residence? Physical presence concerns the total number of days you were in the United States during the period required for your naturalization. Continuous residence concerns the time you resided lawfully in the United States without any single absence long enough to break that continuity for naturalization purposes. Continuous residence means that the applicant has maintained residence within the United States for a specified period of time. Generally, you must have 5 years of continuous residence in the U.S. to become eligible for naturalized citizenship. However, if you are married to a U.S. citizen, the requirement is 3 years of continuous residence, while married to the U.S. citizen spouse. There's an exception if the spouse is a battered spouse. If you spent more than 6 months but less than 1 year outside the U.S., you may be found to have disrupted your continuous residence, unless you can prove otherwise. What's more, if you spend at least 1 year outside the U.S., you will be automatically found to have disrupted your continuous residence, and will have to wait to file your application for naturalization until 4 years and 1 day following the date of your return to the United States to resume your permanent residence. All of this sounds a lot like the principles of abandonment of residence described above, but it's a separate section of the law. You can break the continuous residence requirement without having actually abandoned your U.S. residence. Of course, if you have abandoned your U.S. residence, which sometimes gets discovered in the course of applying for U.S. citizenship, you will have no hope of citizenship and will lose your green card. You may file Form N 490 calendar days before you complete your permanent residence requirement if your eligibility for naturalization is based upon being a permanent resident for at least 5 years, or permanent resident for at least 3 years if you are married to a U.S. citizen. For example, if the date on your permanent resident card says July 4, 2014, you meet the 5-year permanent resident requirement on July 4, 2019. If you have met all other eligibility requirements, you may file your completed Form N 490 days before July 4, 2019. The earliest date you may apply for naturalization would be April 5, 2019. How to determine continuous residence and physical presence. Your time as a permanent resident generally begins the day you were granted permanent resident status. More accurately, a person is considered to be a permanent resident at the time USCIS approves the applicant's adjustment application or at the time the applicant enters and is admitted into the United States with an immigrant visa. The date can be found on your green card next to resident since. However, for certain classifications, the effective date of becoming a permanent resident may be a date that is earlier than the actual approval of the status, commonly referred to as a rollback date. For example, a person admitted under the Cuban Adjustment Act is generally a permanent resident as of the date of the person's last arrival and admission into the United States or 30 months before the filing of the adjustment application, whichever is later. A refugee is generally considered a permanent resident as of the date of entry into the United States. A parolee granted adjustment of status pursuant to the Lautenberg Amendment is considered a permanent resident as of the date of parole into the United States. In addition, USCIS generally considers an asylee's date of admission as a permanent resident to be 1 year prior to the date of approval of the adjustment application. Examples of continuous residence and physical presence. Example 1. Maria. January 1, 2015. Maria becomes a permanent resident through family. January 1, 2015 to January 1, 2020, Maria makes 13 trips to Mexico of 1 month each. So each trip was less than 6 months, but her cumulative trips total 1 year and 1 month. Maria meets the continuous residence and physical presence requirements on January 1, 2020. Maria can apply for naturalization on October 1, 2019. That's 90 days before January 1, 2020. The 13 different one-month trips did not disrupt her continuous residence because none of those trips lasted 6 months or more. Example 2, Edward. January 1, 2010, Edward becomes a permanent resident through employment. January 1, 2011 to January 2, 2012, Edward took a one-year vacation to the Philippines and came back with a re-entry permit. He took no other trips abroad. January 1, 2020, though it's been 5 years since Edward became a green card holder, his vacation from January 1, 2011 to January 2, 2012 disrupted the continuous residence requirement because the trip was over a year. Thus, the clock started again on January 3, 2012. January 3, 2021, Edward is eligible to apply for naturalization under the 4 years and 1 day rule. He can file Form N-400 4 years and 1 day after returning to the U.S. Example 3, Miriam. Jan 1, 2010, Miriam becomes a permanent resident through marriage to a U.S. citizen. January 1, 2010 to January 1, 2013, Miriam travels to England 4 times on one-month trips to see her family. She maintains her residence in the U.S. and continues to stay married to the same U.S. citizen husband. Her combined time outside the U.S. was about 120 days, 4 months. She takes no other trips abroad. As a permanent resident married to a U.S. citizen, Miriam may apply for naturalization after just 3 years. So on October 1, 2012, 90 days before January 1, 2013, she can file Form N-400. The 4 different one-month trips did not disrupt her continuous residence because none of those trips lasted 6 months or more. Exceptions to the requirements. There are provisions for certain types of employment that will not break the continuous residence requirement and generally do not count against the physical presence requirement. You may be able to count your time abroad just like time spent in the United States if you were engaged in one of the following types of employment. If you are in the U.S., Armed Forces time in the U.S. Armed Forces counts as time physically present in the United States no matter where you were. If you served on a vessel operated by the United States. If you served on a vessel registered in the United States and owned by U.S. citizens or a U.S. corporation. If you are an employee or an individual under contract to the U.S. government. Or an American-owned firm or corporation engaged in the development of foreign trade and commerce for the United States. Or if you, an employee of an American institution of research recognized by the Attorney General, or a public international organization of which the United States is a member by law or treaty, if the employment began after you became a permanent resident. If you are a person who performs ministerial or priestly functions for a religious denomination or an interdenominational organization with a valid presence in the U.S. Note: you may keep your continuous residence if you have had at least 1 year of unbroken continuous residence since becoming a permanent resident and obtain an approved Form N-470, application to preserve residence for naturalization purposes, at the time of filing the N-400 application. Note: any time you resided in American Samoa or Swains Island counts the same as the time you resided within a state of the United States. For more information about naturalization, subscribe to our channel and watch our next video.